it together. Alright, this is the last session of the Legal Tech Symposium, so I'm really excited to have you all here. I know some of you have been coming every day this week, which is fantastic. And if you did that, you would have heard a lot of cool talks. I think Monday was about legal tech and law firms, Tuesday was about the future of the legal profession, Wednesday we had a really cool business study about Episort, and we have one of the people from Episort here who's also helped us organize the whole week. I think Thursday was about GCs and how they do contract analysis, and then Friday is about natural language processing and AI and how they play into the law. So to start us off, if this is something that you're interested in, law and AI, our speakers have given us a lot of great papers that you can read. So those are hosted at tinyurl-NLP Talk Papers. So on your own time, you can go there and read. There are, I think, 4 or 5 papers that give you a lot of details on this area. But for now, we have our speakers here and they can talk to you in person. The other thing I want to mention before we get started is if you're interested in, this event is hosted by the Law and Technology Society at HLS. And if you're interested in legal tech, hackathons, law, AI, NLP, all of that stuff, then there's a laptop there, and if you could sign in, then we can put you on our mailing list and give you updates on events we'll be having. Because for example, we're having a hackathon tomorrow. We'll be developing technologies for clinics at Harvard Law School so that they can provide their services more efficiently to people who can't afford other legal services. And with that, I'll start us off. So the first question for our panelists is, just if they could introduce themselves quickly, and I'll start from the left and go down.
Hi, I'm Doug Barnard. I'm the general counsel of a chemical company. I'm also the co-author of a chapter on artificial intelligence in the law that's been accepted for publication and is coming out in the spring. AI and the law combine 2 lifelong interests for me. I'm an MIT physics undergrad and was a coder before I went to law school. So I'm very excited about the convergence of my 2 main areas of interest.
I'm Daniel Lewis. I'm the CEO and one of the co-founders of Ravel Law, which hopefully some of you have heard of. We're a legal research and analytics company. I graduated from Stanford Law in 2012 and started the company with a friend and classmate. We got acquired by LexisNexis last year. And I've had the good fortune of being able to work closely with Harvard over the years through the Case Law Access Project with the Harvard Law Library, digitizing all of these case law reporters that hopefully you'll be able to take advantage of in the hackathon.
Yeah.
Good.
Yeah.
So yeah, that's my background.
My name is Bill Palin. I'm here at HLS. I'm the Access to Justice Technology Fellow. So I work within the clinical programs to think about ways we can build tools and implement them within the clinical programs themselves. So, and hopefully I've met some of you, and that's sort of what I do.
My name is Jacob Rosen. My graduate research was kind of evolving tax evasion schemes, and so I have there was a lot of artificial intelligence in law work back then, and then for 2.5 years I served as the CTO and one of the co-founders of a company that used a lot of patent data and FDA data as tools for R&D researchers, most recently in med devices. So I also have a good amount of background in dealing with legal and legal-ish data and running algorithms.
Great, thank you. And my next question for you all is, could you describe the work you've done with artificial intelligence or natural language processing in the legal field? And I'll start with Jacob this time. We'll go the other way.
All right. Okay. Yeah, so I guess to elaborate, my graduate work was evolving tax evasion schemes. A government contractor was interested in the co-evolution between tax evasion schemes and the way that the IRS audited those tax evasion schemes. So they went to MIT and asked, several years ago, asked if they could look into that. And so my graduate work a few years after that ended up being taking lots of partnership tax law, which is subchapter K, reading through that, actually taking a couple of classes here at HLS because partnership tax law is confusing. And turning that into math equations so then we could stick it inside of the model and accurately evolve really complex tax evasion schemes or abuse of tax shelters, and try to give the IRS guidance as to how the tax law is creating these abusive scenarios. And so that was my graduate work. That was really fun. And then the company that I started afterwards, we spent a lot of time looking at patent data. And the reason why we were looking at patents was we're trying to leverage the structure inherent within legal documents, which is something that's, I think, a pretty common thread through a lot of legal AI, particularly natural language processing. And we were using the technical richness of that data set to use semantic natural language processing, which is based on not like syntax or anything, but the actual meaning of the document to try and weed through patent documents better. And we pivoted like a million times. Our initial business idea was basically patent search for IP attorneys. And over the course of a couple of years, we ended up moving more towards serving R&D teams, again, particularly in med devices, and using similar technology to suck in FDA data and understand defect information. And that, I don't know if you would consider FDA data to be particularly legal documents, but it has a lot of the same issues, which is disaggregated data sets and pretty legalistic language sometimes. So that's my experience with AI.
For me, it's more less technical. I didn't actually graduate from MIT or with a sort of a technical degree. I'm a self-taught programmer myself. I actually started using natural language processing when I first got out of law school, trying to solve a lot of the problems that I had in my own personal practice before I came here to Harvard. I started using natural language processing to look through data and sort of PDFs and documents to try to find personal information so I could redact things faster and to remove them, and started using that and selling that as a service as part of my law firm to help attorneys reduce the amount of time it took and to reduce mistakes when they were finding information when they were trying to do redactions that were 500 pages long. So that was really my initial sort of introduction to natural language processing, and sort of in trying to help improve those sort of tools and algorithms that were laid out in a lot of the modules and the software out there. And I've sort of grown more and more interested in the area as it's grown rapidly, especially over the last couple of years with machine learning. And now we here at the law school will collect large data sets from particular courts, and we'll try to use the tools that are available to try to find discrimination within the court systems, looking at trying to find patterns that we wouldn't normally find, how quickly things are ruled on, so we can sort of educate our clientele and educate ourselves better than sort of the gut reactions that we're all sort of used to, or the feelings we have about particular judges. Right now, we've collected a very large veterans appellate data set that's not widely available or not really collected by, no offense, Lexis or Westlaw, and we're trying to use that to understand better how upgrades decisions are made. In this particular case, the veterans law and sort of the veterans area can be very opaque. The Air Force and the Army and the Navy and Marines don't actually provide a lot of information on how they make decisions, and we're trying to sort of break that apart and use machine learning for that. So that's really how we're using it mostly.
I'm maybe the least technical person on this panel. I come from a family of lawyers. I've got two parents who are lawyers, and both my brothers are lawyers. So I'm actually the black sheep, and I'm not actively practicing. But I got interested in this space and in starting Ravel in law school when I started doing research and realized that the tools we were using looked pretty similar to what I'd seen my parents using 10, 15 years earlier. And it felt like a lot of great technology was being used everywhere else on the internet, and it hadn't yet made it into the legal world. And in addition, the legal world hadn't really started thinking in data-driven terms and hadn't started to kind of take advantage of the approaches and the data strategies that other fields that are different but similar in that they are fields maybe like sports or politics that for a long time have been considered more art than science. We saw those fields starting to take advantage of data-driven tools in ways that seemed really applicable and had a lot of potential in the legal space. So that's in part why we started the company, which was to say, how can we take legal information that's out there and look at it in new ways and build tools that would help people research more confidently or more quickly and achieve outcomes that they couldn't previously. And so to do that, we raised venture capital, but we didn't have a team of attorneys or hundreds of folks who could go through these things by hand, which is generally how Lexis and Westlaw had constructed their businesses. Lots of humans looking at cases, doing a lot of manual work. And we knew that that just wasn't going to work because it wasn't feasible financially, and it wasn't feasible on the timeline that we wanted to go. So we started putting together a team of data scientists who had backgrounds in computational linguistics, working closely with lawyers to train machine learning algorithms that could extract and identify and classify information in case law. And so my expertise is from sort of building those teams, seeing how they work, understanding how we've built technology to take millions of cases and be able to extract a lot of information that's difficult to extract. Things like, does the case deal with a particular kind of motion? If so, what was the outcome? Was it granted or denied? Applying topic classifications to cases using machine learning. So a variety of things like that that help us operate at scale and across a wide variety of documents, but to do it very quickly. So yeah, that's my experience with this.
Right. I entered this area in some ways in a different way than the other three panelists, a way that is probably more typical of yourselves as law students or typical of how practicing attorneys might encounter this. I mentioned before I'm the general counsel of a chemical company. I'm not a litigator. I've worked a lot on mergers and acquisitions, private equity, stockholder activism. I've taught at the University of Chicago Law School 3 courses on those subjects. But as general counsel, I'm also responsible for litigation in our chemical company. And in that role, I developed an interest in corporate veil piercing. And I started to learn more about it, and I came across a fascinating law review article written by a Yale Law School professor and a Columbia Law School professor, and it's one of the ones in the materials, and I highly recommend it to you. But I found the article and started reading it because it addressed the age-old question of why courts sometimes pierce the corporate veil and other times do not. And to my surprise, about halfway into the article, it switched into a very good and detailed explanation of natural language processing and how the professors had used computers to plow through over 10,000 federal and state court decisions where the court ruled one way or the other on the veil piercing question. And with my past interest in computer science and coding background, I said, this is incredibly interesting and useful, and I set out to learn what I needed in order to replicate the professor's work on that paper. And it was daunting. I went about it by taking Harvard's CS50 course online. I don't know if any of you are familiar with that, but I highly, highly recommend that if you have the time. And I liked that so much, I went on to take 7 online data science courses through Harvard. And armed with all of that recent learning, I set about trying to replicate the professor's approach. And with their paper focused broadly on the topic, but as a corporate general counsel, I was interested in a subset of those cases, the ones involving parent corporations and their subsidiaries, the ones involving torts as opposed to breach of contract claims and so on. And so my goal was to replicate their work, and once I had done that, to zero in on the subset of cases of interest.
Great. So the next question is, what challenges have you faced when you work with natural language processing and AI with legal texts?
I mentioned that it's a fairly steep learning curve in 2 respects. One, if, as I tried to do, you attempt to get up enough to speed that you can employ it yourself. Also, in writing my chapter on artificial intelligence in the law, I found it equally daunting to get familiar with everything that is happening today in this space. There are countless startup companies. A year ago, I sat down with Memi and others from Evisort because I was interested in learning more about what's going on in the space, and thought as a general counsel I could help them in return think about the market for their startup company. But in the time since then, as I've co-authored this chapter with two litigators at Skadden, I just find it difficult to learn about everything that's going on in a systematic, comprehensive way. It's like drinking from a fire hose.
I think there's a couple different angles of attack on that question. So one is, I sort of think there's three building blocks to most machine learning today. One is software, the other is data, and the third is the talent that you have working on the project. The software piece is actually not the challenge today. There's a lot of open source software. A lot of the most cutting edge work is open source. The challenge though is customizing it, because it doesn't just work on legal language, for example, out of the box. And so then you get into these two other building blocks, right? Data and the team that you have. The data is important for a couple reasons, and it's one of the challenges, right? So one data challenge is that if you're trying to offer a solution like we do in the legal space, and you're saying, hey, we're a research platform, and if you use us, you can feel confident in your results. We need to have all of the underlying data, all of the underlying cases that you expect to be able to search across, right? So getting our hands on all that data in the legal space was one of the first big challenges we encountered, and it's why we partnered with Harvard to digitize all that material in the first place. The second kind of data challenge, though, is training data. So when you think about customizing machine learning software, you need to give it examples from your domain or of the specific task that you're trying to do, right? So if we're trying to train software to identify cases that deal with motions for summary judgment, we need to mark up by hand cases that deal with summary judgment and have lawyers sit down with the data scientists to sort of go through the clues and the signs so that the data scientists can take that learning and that context and build models from it. And so then that third piece is your talent, right? Of how do you get good people with the knowledge that and the skills that you need to do those sorts of things. And it's expensive, and there's rarity. There's not so many people in the world who have these great skills. But it kind of is a solvable problem if you have enough money and time to hire folks. Two more seconds of this. One other thought, though, that one of the other challenges, right, is adoption in the legal space, which is an interesting challenge on its own right. And kind of as I touched on earlier, I think there's still a lot of awareness that's being built amongst lawyers about what machine learning is, what kinds of products it powers, how to evaluate it in the first place. And there's a lot of marketing buzz and hyperbole that's being thrown around, whether that's the anthropomorphication of software, saying it reads things or it understands or it thinks. Machine learning doesn't do any of that stuff. And it kind of obscures what it actually does. And so it's been really interesting to see the legal space develop over the last 5 years or so and become slightly more nuanced in its understanding of what machine learning can do and does do today. But I think there's still actually quite a long ways to go.
Yeah, I would agree with everything that Daniel said, but I would also add that sometimes when you're looking more at the day-to-day operations of a practice or the work, still getting access to that data can be very difficult, especially if you're dealing not with even cases, because case law is more widely available and easier to access, but sort of the nitty-gritty, like the rulings on regular judgments, right? Getting the court docket information is still very much completely different from state to state, in a lot of cases county by county, locality by locality. Things are spread apart, they've been splintered, so there's really not a good resource or way to collect all the information together. And on top of that, you have sort of these judicial fiefdoms that are very wary to give any information about judicial records. Like, they don't want to be judged, they don't want to be rated, and they're very private about it. And since the judicial branch in Massachusetts is very immune from FOIAs or open data, getting access to that data and getting a large enough amount that you can run it through machine learning, even get to that point, can be quite a bit of a challenge. So I believe, on top of learning and machine learning and sort of getting over that hump, which I think is getting easier with Core ML and TensorFlow, these one open source, one not open source sort of applications. That's all getting so much easier, but still accessing the data and being able to sort of organize it into a way that can then be used is still the hardest part.
Yeah, I kind of separated into two main challenges, both of which have been touched on. First of all is the cleanliness of the data. In my experience, for example, patents, it's kind of more similar to the data that Bill's talking about, which is non-case law. It's issued by the USPTO. And it's an issue because the government oftentimes is forced to publish this data and make it public, but they're not really forced to make it legible or understandable or clean in any kind of way, which isn't it's not a bash on them, it's just a problem with the amount of resources that they have. And so, that it's just like, it's kind of a mess. And really what I think one of the main sources of the mess is the fact that every single time regulations change at all, the data structure changes. And the way, in any kind of ETL pipeline, or any way you suck in the data in a certain particular way, it just completely breaks. And so given that that happens when even a minor regulation is issued, that's a huge problem. And so that's the main thing that we've run into. And just the fact that every single department or every single judge is going to issue data in a different way, so you can't reuse that code, which is just a huge amount of manual labor. The second thing was touched on by Dan as well, is marketing to lawyers. It's difficult enough to sell attorneys tools that they're going to use in-house, because I don't have too much experience with that. I tried to, we tried and failed, but you've had a lot more success with that. But what I find is even more difficult is selling attorneys tools in AI or natural language processing that are going to be client-facing. Because however risk-averse attorneys, in my experience at least, I could be wrong, however risk-averse attorneys are to using internal tools, they're about 100 times more risk-averse when using client-facing tools. And AI and NLP inherently is not going to perform as well as humans to begin with. And so that makes this disconnect where a lot of attorneys and firms are very much unwilling to kind of take a risk to begin with and use a piece of technology that, at least in many ways, is not going to be nearly as good as a human attorney. But the downside of that is that it very much limits access to justice, because you have a lot of these. If this technology was being adopted more quickly, then you would be able to give legal access to many people that don't have it currently. Kind of the stuff that Bill is working on, and it's not a simple solution. It's not. I'm not trying to bash attorneys at all, because it makes total sense. Why would you take the risk in distributing this tool that is not going to work too well in the beginning to your current clientele? But that is what I find to be probably the biggest challenge in client-facing AI and NLP tools in legal tech.
Great. I'm going to be asking my last question now, and then after that I'll open it up to the audience. So if you could all start thinking of questions now. And my last question for you all is, what is the most exciting development in this field for you right now? Start with Jacob.
All right. I think that there are two kind of main threads of exciting stuff. First of all is tech that leverages the structure of legal documents. And this is kind of stuff that Ravel is doing on one hand, like leveraging the structure of case law and looking at connections. I don't know too much about the platform, but it seems like that's a lot of what Ravel does, which is awesome. There's Legit.ai and also Evisort that does contracts, leveraging the structure there, either the syntactic structure or just the way that the document is laid out to leverage stuff. Legit, as a shameless plug, which uses the structure in FDA documents and patent documents to extract semantic meaning. And then there's this other company that's pretty neat called Specifio that does automatic patent document generation. It's kind of neat. It's for some patent attorneys, it's a good starting point. It's like you can just plug some stuff in and it pops out like a template of a patent grant that an attorney then has to go and change, but it's apparently it gets rid of a lot of the grunt work. And then the other type of exciting development is tech that leverages the frequency of certain legal questions. And this is where I view like Bill's work as being really cool, which is that there are a lot of things that people oftentimes want to know, and it's just prohibitively expensive for them to go to an attorney for it all the time. And with relatively, I don't want to say straightforward because I think that sometimes it's really difficult, but there's like a lot of low-hanging fruit with like chat bots and like that, what's that, do not pay, like, do you know what I'm talking about?
Yeah.
What's that called?
Do not pay.
Okay. yeah, just lots of really cool stuff, and it's a really good way to like give access to people, give legal justice access to people that don't have it already. But that's in more cases that's less an NLP deep understanding of the corpus and more of a sometimes peripheral to deep understanding of what people are typing in, which causes its own problems. I'm sure, but I luckily have not had to deal with those.
Yeah, I mean, I think for me the most exciting thing, I mean, all this explosion in sort of technology and companies that are coming out are deeply exciting. I just think the sort of adoption sort of by the large Silicon Valley companies, Apple and Google, that are making these open source or these available tools for machine learning have made it so simple to sort of dive into these projects that, just 2 or 3 years ago were significantly more difficult than they are. So the sort of ease of entry into building this is probably by far the most exciting thing. You can see that really, it's in Google's sort of most recent sort of developer conference, right? If anyone saw what the Pixel 3 can do, right? So that being able to process phone calls, you can see, if you don't know, you can send a phone call to a chat interface so that you can screen the calls, you can read it in real time, and it can sort of understand and ask questions, and you can sort of understand if you want to pick up the call or not. They're working on being able to, and I know there was some blowback from this, but call up businesses across the United States during holidays just so they can ask what their hours are and they can open it up. And so the first person who does that, it calls they ask the Google Assistant, and it calls up the business, asks them what the answer is, and then adds it into the Google searches moving forward, but then texts that back and lets the person know. I mean, the evolution forward is just incredible. I mean, taking 5 years down the road, if that becomes open and available to other sort of low-level developers to interface with clients, being able to screen calls for nonprofits that are working in the legal aid space, to be able to help sort of triage those clients and get a giant resource back. I think that's just incredibly has incredible potential moving forward, and I think as it gets adopted, it'll become less scary to attorneys who are really afraid. I hadn't really thought about how scared they would be to even put something forward, but it makes it easier for them to do that in the long run. So I think those are sort of by far the most exciting things that I think.
I agree with all of that. I think the growth in the number of legal tech startups has been really fun to watch. For those who are tracking these things, I think they're saying that there's now 2,000 or 3,000 startups that are trying to take on all various parts of legal practice, not just research, but case management, billing, all sorts of things. And most of those will fail, but some of them will probably be really successful. And I think the diversity of creativity that's out there right now is a really good thing for the legal space. More particularly in my world of looking at case law, the things that I'm excited about are sort of twofold. One is, as we get better and more sophisticated at understanding exactly what happens in cases, we have a better model of what's likely to happen in cases. So our ability to tell you that in front of a particular judge with a particular kind of case, there's a 60% chance that the motion is going to be granted. We're continuing to get more and more granular and accurate about those kinds of outcomes, and to be able to turn it into things that are predictive. So tell us about your case, tell us about the asserted defense, tell us whether the other side's represented by an AmLaw 400 firm. And given what you tell us about the case, we can offer you a prediction with some pretty good confidence about what might be likely to happen. And I think that's going to continue to play out. We're still at the very early stages of this kind of analytics, but the depth of what we can start to tell you about what's likely to happen in cases and what's likely to unfold, if the motion fails, what happens next, that kind of thing, is really interesting. And it's going to touch on a lot of different spaces, including one that I'm very interested in, which is litigation finance. So we can talk about that if you have questions. The second thing is working with language in particular. One of the things that we focused on at Ravel was identifying language that judges find persuasive. So looking at their own opinions when they write, what cases and language do they commonly use? And we've noticed things like, this judge commonly cites this phrasing of the rule, and they copy and paste it 75 different times in every motion to dismiss that they write. And as we get more granular about that, I can see it pivoting into something like creating the starting point, the skeleton of a new draft. So if you as an attorney are thinking about writing a brief, let's start that up with some language and cases and argumentation that might be persuasive based on what we know about the judge in the case. So that's kind of an interesting next frontier, I think, in looking at language.
It's an exciting area. It's hard to pick one exciting development. But for me, it's probably the Second Circuit case, Lola versus Skadden Arps, and it's described in one of the 4 papers at the URL. David Lola was a contract attorney doing very routine work on major litigation on a Skadden Arps lawsuit. And being a member of the California bar and very bored and unhappy as a contract lawyer, he filed suit against Skadden Arps because they weren't paying overtime, even though he worked 50 or 60 hours a week. He lost in the Southern District of New York because under the Federal Labor Standards Act, lawyers are not entitled to overtime. But he, oddly enough, appealed to the Second Circuit, and they reversed, and he prevailed. And the case is very significant, and the significance is spelled out in this law review article. Because the basis for overturning the Southern District was that if a machine can perform the task, then by definition it's not the practice of law. And the implications of that for the business of law are profound, because it represents a path for accounting firms, for example, for startup companies, to do things that were formerly the exclusive province of lawyers. And as the technology improves, and it's improving exponentially, machines can take over more and more of what attorneys currently do. And so I think that is a profound shift in the landscape, and one that bodes well for people who are developing these machines, for accounting firms and others who would love to get into the practice of law. When I was at Kirkland & Ellis, I represented Hitachi in a number of transactions. And outside of the US, they get legal services from KPMG, not from law firms. But in the US, they use Kirkland & Ellis because KPMG cannot practice law in the US. But to the extent you can do more and more through this technology, I think that law firms will face an increasing competitive threat from accounting firms and startup companies.
Great, thank you. Any questions from the audience? Yeah.
Yeah, so my question is about some of the more abstract functions or sophisticated functions that lawyers engage in, things like analogical reasoning, issue spotting, sort of statutory interpretation. And with regards to these tasks, where is the legal industry now? How are algorithms sort of dealing with those tasks, if at all? What do you see the barriers to sort of moving in that direction? And where do you think the field's going to be with regards to some of the more difficult tasks the lawyer faces in maybe 20, 30 years? And this is general panel.
I'm going to go first. On the topic of corporate veil piercing, you would think that a computer would be particularly ill-suited for the task of trying to discern why judges sometimes curse the veil and other times do not. Future Chief Justice William O. Douglas wrote a law review article in 1929 on the subject and essentially admitted he was stumped. And many bright lawyers have been stumped in the intervening decades. But through the use of natural language processing, the law professors feel they were able to, working in conjunction with the machine to be sure, crack the code. So I think, you know, that's only an example, but it illustrates the long-term potential of these technologies.
I don't know sort of generally how to answer your question, so I'm going to talk adjacent to it. You know, it reminds me of sort of Gary Kasparov talking about how, you know, eventually computers got better at this at chess, but then with a human being with the computer, they're able to beat the computers, right? So like there's some creativity or there's some output together, mixed together, that allows them to even get further along than we were before. I wouldn't be surprised if the tools are really good at, once they're integrated with the attorney, to come up with really novel things much faster than they would, you know, before. So that's what I would expect where it would get. You know? So we don't need it to replace completely, but you know, maybe you can make some big improvements that way.
Yeah, I'm not worried about the long-term viability of practicing law at all. I think there's a lot of interesting, complex work that's out there. When you think about a litigator's day-to-day today, about 30% of their time is spent on research right now. And that's the space that I've focused a lot of my effort on. And I think there's sort of two hypotheses of just what technology improvement in that space might do. So one is say, okay, maybe the tools help you do research much more quickly, and that 30% of your day goes down to 15%, and you spend that extra 15% on the higher level tasks like writing and synthesis and client communications. That might happen. The other hypothesis would be what's called a bounce back effect, which is to say, the quick analogy is, imagine you live on the suburbs of a city and it takes you 30 minutes to commute downtown, and they build a highway through your town and out 100 past miles, and all of a sudden you can commute downtown in 10 minutes. Well, it turns out that folks way past you can now use that highway as well, and they start commuting, and your commute sort of creeps back, and before you know it, it's 20 or 25 minutes again. So applying that to the information legal space, you could think, okay, well, maybe the technology actually helps you cover a lot more ground in your research than you previously did. Now, when you think about research, you're not just looking at cases, but you're understanding how the judge rules, you're looking at analytics, but you're maybe spending the same amount of total time. You're just covering a lot more material. You're being more confident. You're getting better results. And I think that sort of touches on this sort of Gary Kasparov model, saying technology working in conjunction with the smart human is going to go further.
Yeah, and any kind of complex legal, I mean, I think I'm the only one here that doesn't know about law degree, and so, you know, take what I say with a grain of salt. But when I was doing my research in the abusive tax shelter stuff, one of the things that we were doing, we were trying to somewhat replicate a very experienced tax attorney doing tax planning, abusive tax shelter creation, whatever you want to refer to it as. And really, it's just a series. It's like the human, the part that I personally think is inherently human, the part that I think is very much doable by a computer, they're very intertwined. And so to Bill's point about the Kasparov thing, people about humans and computers working in conjunction with one another, I think it's just, I mean, it's a boring answer, but I think it's going to be on a case-by-case basis. And for example, in partnership taxation, there are many points at which, like saying, okay, let's say there's a distribution of stock to all the, you know, owners of this partnership. Then there are a series of quantitative things that happen. Tax flows through to the owners of the partnership. Certain events are triggered that are very straightforward. But at the same time, trying to determine whether or not a certain type of activity was active or passive. I don't think that's something that really a computer can do, at least in the foreseeable future. And so, yeah, I mean, it's more just kind of repeating what's already been said. But I think every single situation you're going to find different tasks that are computational, different tasks that are not. Like, just think about how much, like control find or Apple app in a Word document helps people. You know, it's a pretty trivial example, but it's just intertwined with every single aspect of what people do.
Thank you. Any other questions? Jeff?
So most of the law students are probably going to end up going to law firms, right? And once you start getting, when I worked at a law firm this summer, they were extremely low tech in terms of like writing briefs for even their IT and cybersecurity. And it's like, this is a question that probably is more soft and hard to answer, but like, how would you actually convince, you know, senior associates or partners to actually adopt these technologies, or how can you convince them to give you the time to maybe develop like some small process improvements or something like that?
Yeah, honestly, the biggest macro barrier to firms taking on new technology is policy one, which is, you know, as Doug touched on, the rules around firm ownership and being able to split profits with non-lawyers, and the rules around practice of law. If those things change, I think you'd see a vast amount of change in legal practice more broadly. But I couldn't tell if your question is also kind of at the very tactical level, like how do you sell into firms, given that many of them are very low tech. And I've had experience trying to do this, and it's hard. But in general, you know, we focus on making technology where we could go to associates and say, hey, we're going to make your life better. And the results were often, we would get a call from an associate saying, like, thank you. I just spent 2 hours looking for something in Westlaw. I came into Ravel and found it in 2 minutes. And so one of the stereotypes of the legal space is that lawyers don't care about efficiency because they're on the billable hour. And I think there's times when that's maybe true. It's much more true at the business level than at the individual level, though. And so when individuals face technology that can help them be more efficient, can help them make a more confident decision, I think it's pretty easy for them to say, yeah, I want that. But firms as a business are pretty bad at buying new technology and adopting it because they're not run like normal businesses, because they will share profits with excellent non-lawyers. So that sort of systematic problem is one of the reasons why across the board you've seen generally pretty low innovation in how firms operate and adopt technology. There's a few examples out there, but very, very much the exception out of the rule.
Yeah, so I have a little bit different experience than you guys would mostly have. I went to Suffolk and started as a solo right out from law school, which I'm assuming none of you guys are planning to do. So I started using technology to sort of supplement, you know, I graduated in 2012, took the bar in 2013. So around 2013, I taught myself a program, and I started using the technology, these skills that I had to improve my practice. And what I started realizing was I kept solving these problems, and I thought, and then I was able to turn these into subscription services that I would then sell to other attorneys. And so, two points, if I can remember two. But I would have to go door to door to sell this tool to attorneys. I would go to bar associations and be like, hey, you know, give this to your membership free for 15 months. Just like simple, built a simple tool that all it did was check your docket in Massachusetts, and then if something updated or changed, it would just send an email. No interface. They didn't want an interface. All they wanted was an email as soon as it updated. It was great for me, right? I didn't put together a nice website, just you sign up, and then I got my little monthly checks in my inbox, which was amazing, by the way. You can do that. It's such a great feeling. But it was really about solving a problem that I had faced, and I knew when it was something that I really wanted to solve, I really liked, it worked. And so I was able to slowly build it up. And what was so valuable to some of these attorneys was it was solving a problem they didn't have a solution to, and it didn't really hurt them, right? So once people started getting dockets updated, they would be able to catch errors that they wouldn't normally have been able to do. It was solving something like, you know, a clerk put the wrong ruling, was about to mail it out, right? And it was gonna, you know, go out, and they were able to, you know, see that this was the wrong docket, the wrong information, they were putting the wrong thing in. They'd be able to call the court, and they'd be able to have it literally pulled out of the outgoing mail and fix the problem before it started, right? Or really just getting to know when your ruling happens, so you get at least a day or maybe two if you're in Boston and you're out in Worcester and it's going to take 2 days for the mail to get there, your appeal, right? Because it's running from when the decision is docketed in the court system in Massachusetts, right? So finding problems that they don't know that they have, there are all these other things, legal technology, but there might be other tools they hadn't even thought about. And I think that can be a really eye-opening experience for upper level management. So,
I give you a little more granular sense of it. In the litigation area, the large law firms, big law, have been making extensive use of AI, e-discovery and so on for probably 10 years or more. And so they would have in the litigation practice group a very open mind about additional uses of technology. There are parts of the world, the Magic Circle firms in London are quite a bit further down this path than their US counterparts, same in Canada. But I think that all law firms are under pressure and increasing pressure to learn more about this and start to use it. And the pressures are coming primarily from clients, general counsel such as myself, just seeking efficiency, better results faster. But increasingly over time, as more law firms adopt technology, there will be pressures from their competing peers.
Great. I think we're nearing the end of our time, so you all can come and talk to our speakers after this if you want, but until then, will you join me in thanking our speakers for coming here?